Judge Fowl continues, "It also seems to me that it is a proportionate response in this case. No progress can be made towards resolving the issues in dispute unless and until Miss Ashwell surrenders herself to justice, and she has given no indication that she is prepared to do so. Even if she were, it is far from clear that the situation is salvageable given the real apprehension on the part of the respondent about her conduct. Apart from inviting me to recuse myself, she has put forward no factors or reasons which would lead to another conclusion. She has not in fact addressed the reasons for a potential strikeout order at all, focusing her attention instead on ways of continuing the litigation remotely. In all the circumstances, I can see no realistic alternative to a strikeout order at this stage. Mischaracterization of compliance and intent. The tribunal asserts that no progress can be made unless and until Miss Ashwell surrenders herself to justice. This misrepresents the situation. Excuse me. My non-attendance was not an attempt to evade lawful instructions, but a protective measure following repeated retaliatory arrests, police misconduct, and stalking by the respondent's associates, including Camilla Kerslake. Denying me remote access while allowing the respondent to participate by video constitutes a procedural irregularity and breaches Rule 47.2 of the Employment Tribunal Rules of Procedure 2013, which obliges the tribunal to consider legitimate reasons for non-attendance. Bias in tribunal reasoning. The tribunal frames my recusal requests as irrelevant or personal, when in fact I formally requested recusal 5 to 6 times, citing documented evidence of apparent bias and partiality by Judge Fowl. These requests were based on objective concerns about fairness and impartiality, yet they appear to have been dismissed without consideration, demonstrating apparent bias in violation of Rule 3 of the Employment Tribunal Rules of Procedure 2013, which requires tribunals to act fairly, impartially, and in accordance with the overriding objective. Misrepresentation of alleged apprehension. The tribunal asserts there is real apprehension on the part of the respondent about her conduct. This is factually misleading. Any concern expressed by the respondent stems from their own orchestrated intimidation, harassment, and defamation campaigns, not from any legitimate risk posed by me. Framing the respondent as fearful while presenting me as a threat inverts reality, undermining the fairness of proceedings and the presumption of innocence. Failure to consider proportional alternatives. The tribunal concludes there is no realistic alternative to a strikeout order, yet ignores less drastic proportionate measures such as remote participation as previously granted by another employment judge, protective measures for the respondent if genuinely needed, and procedural safeguards under Rule 3 and Rule 38(1)(b) to manage disputes without terminating the claim. Conclusion. The reasoning in paragraph 26 minimises the claimant's rights, misrepresents the facts, and conflates civil proceedings with unrelated criminal matters. The strikeout decision in these circumstances is procedurally unsafe, disproportionate, and demonstrates apparent bias, justifying appeal. The tribunal has failed to give due weight to the evidence I submitted, including documented threats, harassment, and retaliatory actions by the respondent and associates.